Changes happen at the USPTO from time to time. There were new procedures that went into effect earlier this year at the beginning of 2022. Last year, there were fee increases that went into effect. Almost every year, there's some kind of change that happens and impacts the USPTO and impacts those of us who file trademark applications at the USPTO. But the biggest change that I've seen in many, many years is about to take place. In early December, on December 3rd, the USPTO is changing the time that most applicants get to respond to an office action. An office action is a refusal from the USPTO. Sometimes it's a big refusal with lots of issues and big substantive things. Sometimes it's a fairly straightforward refusal, might just have one relatively minor procedural issue. But for many, many years, for as long as I've been practicing trademark law, which is more than 2 decades, when an office action issued, the applicant had 6 months to respond. Not so anymore starting in December. In December, applicants will get an initial response period of just 3 months, cutting the time period in half. This is a huge change, especially for law firms and the way they manage their caseload. It's also going to be a change for client communications and for clients to have to make decisions and provide information to their counsel to help with a response depending on the issues. Now, it doesn't impact all applications. Some foreign filed applications will not be subject to this rule, and it doesn't impact office actions issued post-registration, which are relatively few and far between. And so when we talk about an office action generally, we're talking about a pending application. And all pending applications, except for some of those foreign filed ones, will now have a 3-month response deadline. There will be an extension available for a fee, but that's an additional fee, and that's an additional deadline to keep track of and a filing to submit. And so while it's good that there's an extension available, it's not the same as what the current system is because there's more work that goes into getting an extension and more cost to the client. So I am really not pleased with this change. I voiced some of that displeasure when the rules were being proposed. However, it is what it is. The rule is now upon us imminently, and this new 3-month response period is the biggest change that I have seen to trademark practice in many, many years. If you have questions about the new rule or about other trademark procedural issues, feel free to reach out to me, info@ericpelton.com. That's ERIKPELTON.com, or visit the website and you can find a Connect with Us button there.